All right, I've got 12 o'clock on the dot. So let's go ahead and get started. For those of you who don't know me, my name is Abby Brenneman, and I'm the program coordinator at Arkansas Access to Justice. Access to Justice is a commission. It's also a nonprofit. The mission is right there in the name. Our whole goal, everything that we do, is to increase access to justice, to make the court system more accessible to marginalized groups, especially low-income individuals. And so one of the ways we do that is by providing education, CLEs in particular, and know your rights, CLEs in particular for attorneys. If this is of interest to you, I do want to just let everyone know that we are doing a Conozca sus derechos, which is know your rights in Spanish, this following Monday at 6 p.m. if you have any clients or anyone that you think might benefit from that. Okay, so just once again, I want to remind everybody that the CLE attendance forms are going to go out in an email after this. I will also include copies of today's presentation. All right, so our speaker today is Amelia Steven McGowan. She's assistant clinical professor and immigration clinic director at the University of Arkansas School of Law in Fayetteville. Prior to joining that school, Amelia served as the immigration campaign director at the Mississippi Center for Justice. And there she focused her practice on appellate representation of asylum seekers and led a team of pro bono attorneys to represent over 100 Mississippians impacted by the 2019 ICE raids in central Mississippi. Amelia also worked as an adjunct professor at Mississippi College School of Law, where she taught immigration law and directed the school's immigration clinic. Amelia has also served as a commissioner on the American Bar Association's Commission on Immigration since 2021, and she represents the ABA in an international asylum working group as part of the Law Society's Compacting Forum. So without further ado, your presenter for today's CLE, Professor Amelia McGowan.
Thank you so much, Abby. I'm really grateful to you and the Arkansas Access to Justice Commission for the opportunity to speak today. And I'm really thankful to everybody who is here participating. So I want to just kind of give a brief overview of immigration law. I know that many of you may not have experience in immigration. You might be focusing on other fields. But I want to talk about the ways immigration might impact the work that you do. And also at the end, since this is Access to Justice, talk to you about some pro bono opportunities. So just a second, I've got a brief presentation for everybody to kind of help guide us along. Let's see, here we go. Great. So really excited to be here with everybody today. As Abby mentioned, I am the director of the immigration clinic at the University of Arkansas School of Law in Fayetteville. And I'm pretty new here and I'm really excited to be in Arkansas. So I just started up here in August and we've already had a couple of snows. So it's snow on the ground today, which is a wild experience for me as a Mississippian, but previously came from Mississippi, and access to justice is something that is critical for me in the work that I do. As Abby mentioned, I worked really closely with a number of pro bono attorneys in Mississippi who were really instrumental in getting representation for Mississippians impacted by the ICE raids in 2019, in which 680 people were arrested. And many of whom were placed in immigration removal proceedings. So this is a topic near and dear to my heart, and I'm so excited that y'all are interested and are here. So the work that we do at the immigration clinic, we represent people who are non-citizens in Arkansas, many of whom are facing immigration situations. So many of our clients are in removal proceedings, what we used to call deportation proceedings. Many of our clients are seeking asylum. Many of our clients are victims of crimes, so just domestic violence. And so I want to talk to you about some of that work that we do and give you a broad sort of view of immigration and how it might impact the work that we do. So why immigration? I've already touched on this a little bit, but this is a topic really relevant all over the United States, but here in Arkansas, there are particular interests. One thing that really drew me to the area was how much immigration has grown. So it's a hot topic in the area. And like I said, it probably impacts the work that you do, even if you don't practice immigration. So just to give you some stats about Arkansas, according to the American Immigration Council, 5% of Arkansans are immigrants, and another 5% have at least one immigrant parent. And then households led by immigrant Arkansans paid over $700 million in federal taxes and over $380 million in state and local taxes in 2018. So immigrants have a huge impact on Arkansas and are an important part of the population of Arkansas. So what I'm going to talk about today is just to give you a broad overview of immigration law. There's a lot that we can't cover. So back in Mississippi, I would give a whole semester class on immigration law, and even in a whole semester, we couldn't cover everything. So I'm just going to give some basics. I want to give you an idea of what some immigration protections are and remedies are out there in case you have clients who might benefit. I want to talk about some of the many challenges in obtaining those benefits, even for people who have several years of residence in the United States, jobs, families, and pay taxes. And I'll also give you an idea of some questions to ask if you have a non-citizen client, to know how to refer somebody out for immigration counsel if that is needed. I'm also going to talk about intersections with other fields. So I understand we have some practitioners in family law. There's a lot of overlap, as you might imagine, as you might have experienced with family law. I want to talk about the intersection of criminal law and immigration law, both in terms of what a criminal conviction might do for somebody who is a non-citizen, what that might mean for their immigration case, and also what benefits and protections are available for immigrant crime victims in the United States, particularly victims of domestic violence. And also, at the very end, I'm going to talk to you about some pro bono opportunities. If you do not have experience in immigration, or you have a little experience, and you'd like to get involved, we've got some great pro bono opportunities if you'd like to be involved, and we have mentorship possibilities if you don't have immigration experience. We can guide you through the process and mentor you through the process. So today, this is a brief overview of everything we're going to talk about today, just to give you an idea. Some of it's very broad and some of it's pretty narrow. So as I mentioned, we're going to start with an orientation to give you a general structure of immigration law, what some common misconceptions are. Problems in immigration law: you may have somebody coming to your office, they might be raising an issue about their immigration status, or questions about how immigration status might impact these other areas of law. So this will help you identify some issues if someone comes into your office with possible immigration issues. And then solutions. What can people do if these problems pop up? Again, I'll talk about immigration options, but also kind of giving you the tools to know when you might want to refer somebody out. Particularly with, if you practice family law and you're working with a non-citizen child who's been abused, neglected, or abandoned, we'll talk about some immigration options for them, or for example, DV survivors. And then after that, I'm going to talk about your questions. So we're going to have a little time at the end where you can, raise any questions that you have, any particular concerns you have about immigration or how it's popping up in your line of work. So first, a brief orientation, just so we're kind of familiar with the immigration landscape. The structure of immigration law, if you practice another area of law, immigration law is very broad and very diverse. And the structure can get a little confusing even for immigration practitioners. So just to give you this is a really generalized sort of view, but think about it sort of immigration externally, people who are wanting to come to the United States, and then things are happening internally. So we have a lot of government players in immigration law, as you might imagine. So first of all, you have a lot of people who are wanting to come into the United States, but are not yet in the US. And they are seeking some kind of visa to come into the US. It could be like a student visa, a work visa, an immigrant visa to come live with a close family member, something like that. So the US Department of State handles those immigration cases, and those are handled at our embassies and consulates abroad. But then a lot of immigration issues obviously happen at the border and internally. So we have the US Department of Homeland Security that was created after September 11th, and they handle almost all aspects of immigration inside the United States and at our borders. So you might hear of an organization called USCIS, that's US Citizenship and Immigration Services. They handle really almost everything affirmative within the United States. And that means people not facing deportation or removal proceedings. Or it could be outside of those proceedings if they are. So these are things like people who are, have family in the United States and they're also living here and they're trying to get a green card through their family. It can be things like people seeking protection because of domestic violence, VAWA, we'll talk about in a minute. It could be people who are seeking US citizenship or naturalization. So a lot of things inside the United States that are not in removal proceedings. And then we also have internal enforcement. So we have US Customs and Border Protection at the borders and at the ports. And then we also have ICE, Immigration and Customs Enforcement within the United States. You often hear their names, for example, when people are transferred from the police to ICE custody. And ICE also has their own enforcement operations within the US. So the Mississippi raids that I mentioned back in 2019, that was an ICE operation in conjunction with some other federal agencies and they arrested 680 poultry workers in central Mississippi. So those happen within the United States. We also have some players in the removal process. Remember, I talked about deportation, what we used to call deportation. Now we call removal proceedings. And these are the proceedings where the US government decides whether a person is removable from the United States. So whether they can carry out the process of removal, enter an order of removal and then actually remove a person. So those proceedings are conducted under the Department of Justice in an organization, like a sub-agency called the Executive Office for Immigration Review. You'll often hear immigration attorneys call it EOIR, like the donkey on Winnie the Pooh. It's EOIR. And those proceedings, those are adversarial proceedings. The Department of Homeland Security that I mentioned before is the prosecutor. And but the DOJ represents the government before the circuit court. So these cases can make it all the way up to the circuit courts and US Supreme Court. So that's kind of the structure of all the agencies involved. There are other agencies involved, for example, with unaccompanied children, that's Health and Human Services, but that's kind of more complicated and outside the scope of this presentation. Now, in terms of the sources of US law, so there are a number of sources of US law, many of which you're probably familiar with, some of which you might not be. But the backbone of US immigration law is the Immigration and Nationality Act. So that's Title 8 of the US Code. But when you hear immigration attorneys in courts reference these sections, you'll often hear it called INA and then the section number. So you'll often not see it cited at the US Code citation. So INA 101, for example, is definitions, 208 is asylum. So it's a whole series of laws governing immigration. Now, these are really the backbone of immigration, but if you take a look at them, they leave a lot of sort of question about their kind of details. So while they're the backbone, we have a number of laws that really sort of fill in missing pieces. So we have case law. Importantly, some cases from the US Supreme Court, but that's not the bulk of the case law that we work with. Primarily, we deal with circuit law. So as immigration proceedings move up, particularly from removal proceedings, we have immigration courts all throughout the country. Those cases move their way up to an agency court called Board of Immigration Appeals, and then to the circuit with jurisdiction over that immigration court. So every circuit has its own sort of interpretation of immigration law. And that can make a huge difference. I've practiced in 3 circuits, and while the changes, the differences can be pretty nuanced, some of them can be pretty stark. I practice asylum, for example, and there can be stark differences over how a circuit defines persecution, or how a circuit defines a particular social group. So that can mean that someone can win in one circuit with the same facts and lose in another circuit based on the circuit's interpretation. So circuit law is very important. We also have a number of executive actions, orders, memos, agency guidance. We have federal regulations that also fill in a lot of these gaps in immigration law. So we have the Code of Federal Regulations. The Board of Immigration Appeals that I mentioned, that's the first appellate level from removal proceedings. They're nationwide, they're under the Department of Justice. They have some published opinions. We also have agency guidance and memos and manuals. We've got executive orders and memos. These are things that might set enforcement priorities by the president. Maybe programs like DACA. So many of you have probably heard of deferred action for childhood arrivals. That was an executive action. And then finally, last but not least, we have international treaties. Some of our immigration law, particularly asylum and related protections, are actually based in treaties that the US has signed. So our asylum and related protection of withholding removal actually comes from the 1967 UN protocol relating to the status of refugees. And then our protection for torture victims comes from the UN Convention Against Torture. So that's another source of law. And the US Congress has adopted those. So it's important to keep in mind. Now, common terms in immigration. Immigration has a lot of sort of very particular terms that we can't go all into today, but just some really common ones that trip up a lot of people who are new to immigration. Immigration has a designation between a person who's called a non-immigrant and an immigrant. So while we often say in sort of common parlance, we'll say somebody's an immigrant, but in immigration law, there's a very particular definition. An immigrant is somebody who is not a non-immigrant. And a non-immigrant has a whole series of definitions in the INA of different types of visa categories that qualify a person as a non-immigrant. And I'm going to talk about those in a second. Also, green cards. So many of us have heard of green cards, but green card means that a person has permanent residence in the United States. The cards, in most cases, are valid for 10 years, but your status is permanent unless you commit some kind of immigration violation or a crime that prompts the US government to try to revoke your status and you'll be placed in removal proceedings. So that can happen. Abby and I were just talking about, I went to San Diego a few weeks ago and worked with a project through the ABA's Commission on Immigration, who is providing services to deported veterans, US veterans, many of whom had their green cards, and those green cards were revoked because many of them had gone to war, had come back, sometimes gotten involved in drugs, had gotten drug convictions, and had their green cards revoked. So they are now living outside the United States. So they're providing services to them. So green cards can be revoked. Green cards can also, though, are also a pathway to US citizenship. So, for example, if you had your green card through marriage to a US citizen, once you've had your green card for 3 years, you can petition for US citizenship. If you have gotten your green card another way, like through asylum, after 5 years of having your green card, you can petition for US citizenship. Also, you'll hear the terms removal and deportation, which I just talked about. So deportation is the old term, removal is the current term for the process and then the action of deciding whether the US government has the authority to remove a person, order them removed, and then physically remove them from the country. So we'll talk about that process, and that happens in immigration court. And then finally, naturalization. So that's the process of a non-citizen becoming a US citizen. As I mentioned before, generally have to go through that process by having a green card first. So that's an important key term. Now, before we get into some immigration options, I want to talk about some common misconceptions that people have about immigration law. So there are a lot of misconceptions about migrants generally, and those are really important to discuss. But given the focus of our presentation and the time limitations, I'm going to focus on a few misconceptions about immigration law specifically. So if you make the mistake of reading internet comments about immigration, one of the common points you'll see or reactions that you'll see is a person will say sometimes, why don't they just apply for citizenship? Or why don't they just apply for a green card or apply for a work permit? It's really important to realize that you have to have a legal basis for doing so. And many times those options are very narrow and very limited. So this is just a map by an organization called Immigration Road. It talks about the different pathways to get to a green card, all the barriers you have to jump through, and all the places where you could hit dead ends. It's important to realize that many people, regardless of length of time in the United States, regardless of good conduct while in the United States, regardless of having paid taxes in the United States, some people will never have an immigration option. So it's important to remember that. Relatedly, there's a common misconception that if a person who is a non-citizen has a US citizen child or US citizen spouse, that having that child and or spouse will protect them from removal and or give them automatically an immigration status. That is not the case. If you, for example, entered the United States without authorization, if you entered without documents, without being inspected, as we say in immigration law, you will have a very hard time getting a green card through marriage. You have to jump through a lot more hoops. You actually have to leave the country in most cases. So it can be really complicated. And then a US citizen child can't petition for you until they're 21. And you can still run into those same barriers if you entered without status in the first place. So just to give you an example from Mississippi, when we had the ICE raids, a number of people who were impacted by the ICE raids had US citizen children, but that was not a sort of immediate protection from removal. Now, there are some protections from removal that do involve children, and that is a factor the court will consider. The children are a factor the court will consider, but that's not an automatic protection by any means. The other misconception that you kind of frequently hear is that asylum seekers must seek protection at a consulate or embassy outside the United States or at a US port of entry. So there are two problems with that. Seeking protection at a US consulate or embassy outside the US doesn't recognize that. That's called political asylum. The US doesn't recognize that. For the US, you have to seek protection either at the border or internally. And US asylum law says that you have to be just physically present within the United States or at the border, regardless of your immigration status. So that's an important concept to remember. Now, getting into general categories of migrants. So if somebody comes into your office and they say, I'm having an immigration issue, they might talk to you about this. They might say, I'm here on a student visa, or I have a green card through marriage, or I have DACA. So I wanted to give you these categories so you can kind of see how they fit, how these different statuses you might hear about fit within US immigration law. So first we have, non-immigrant visas. As I mentioned before, these are all types of visas that the US code designates. They're designated by their number, their number and then subsection. So the subsection is a letter, and that becomes the letter of that visa. The visa is known by that letter of the subsection. So for example, subsection F talks about students. So F visas are student visas. We have K visas for fiancés. So K visas are fiancé visas. So there are a whole series of non-immigrant visas. They generally involve work. So we've got some sort of temporary work visas that are in this category. You might have heard of H-1Bs. They're in this category. We've got studies. You've got the F visas and J visas who are students and exchange visitors through educational programs. We have certain humanitarian non-immigrant visas. You might have heard of U visas for crime victims. I'll talk about that in a minute. Or T visas for trafficking victims. I'll talk about that in a minute as well. So those are non-immigrant visas. Now, immigrant visas are for people who are seeking to stay permanently as green card holders. These are folks who are coming from outside the United States, applying for these visas, and coming in as immigrants, getting their green card. So these fall into the general categories of family. So you'll often see this in families. You might have a US citizen spouse in the US who's petitioning for you to come on an immigrant visa. And it can also be employment. So you have employers petitioning for people to come into the United States for work. And these can be really, really complicated processes, especially for the employment immigrant visas. Now, immigrant visas you're getting from outside the United States, non-immigrant visas you can get from outside the United States, you apply from abroad, or either you can, in some cases, like especially the humanitarian ones, get from within the United States, but that can be pretty tricky. You could also switch from non-immigrant visa to a different non-immigrant visa. It's called change of status. And sometimes you can move from a non-immigrant visa to a green card. That's called adjustment of status. So you might hear those terms as well. We also have some special humanitarian protections in immigration law, and some of these overlap with the first two categories. So as I mentioned before, the T and U non-immigrant visas are for crime victims and trafficking victims, respectively. We also have protections like asylum that I'll talk about in a minute, and its related protections, as well as things like protections like DACA that were created by executive action. So we'll talk about that as well. And then finally, we have a category of people who don't have immigration status or any type of protection, undocumented immigrants. So these are migrants who enter the United States, either enter the United States without status. As I mentioned before, in immigration, we call that entry without inspection. Or they may have entered with a visa, like a non-immigrant visa, and then now they're out of status, so they have no status. And there are particular concerns and complications for people who fall into that last category of undocumented immigrants or migrants. So when I mentioned before, we have the immigrant visa and the non-immigrant visa, I just want to give you a couple of differences just so you can conceptualize this. As I mentioned, the immigrant visa allows for permanent residence, a green card, and importantly, a pathway to U.S. citizenship. If somebody comes to you with a non-immigrant visa, that non-immigrant visas generally allow entry and or residence for a limited duration or purpose, although that could be years. And sometimes you have the opportunity to file for an extension. In many cases, non-immigrant visas are not a pathway in themselves to a green card or subsequent U.S. citizenship, but there are more options. Now, the humanitarian categories, like U visas and T visas, you can apply for green cards after a certain period of time. But many things like student visas, you don't have that option. You have to get your employer to petition for you for an immigrant visa, for example, or something like that, because it inherently doesn't have a pathway to the green card. Now, important for our discussion, if somebody comes to you and they're undocumented, you might think, well, why don't they just apply for one of these visas? For both of these categories, visas in both of these categories, you first have to meet all the statutory requirements for eligibility, and also you have to be admissible. So one thing that makes you inadmissible, for example, is having entered without inspection or maintaining a lawful presence. So there are a number of inadmissibilities in U.S. immigration law that can just take these options off the table. Now, if immigration law allows for some waivers in some of these categories for some grounds of inadmissibility. These are generally, though, not always, but often the humanitarian grounds, humanitarian non-immigrant visas. So having an inadmissibility might totally foreclose many of these options. That's important to think about. Now, these humanitarian protections, I want to talk about kind of what do they cover and how you might see it in your office. So, as I mentioned, there are kind of more waivers for these humanitarian protections, or some exceptions where you don't even have to seek a waiver. So these are often protections for some survivors of domestic violence, human trafficking, and other violent crimes in the United States. It can be protections for people fleeing persecution and torture abroad, so people who are afraid to go back to their home country. It can be something like temporary protected status, which is authorized by the president. These are country-specific protections for citizens who can't return due to civil unrest or natural disaster. So we have TPS, for example, now for citizens of Cameroon, Venezuela. There are a number of other countries that fall into that category. And also, some U.S. immigration law offers protection for children who have suffered abuse, neglect, or abandonment by one or both parents. That's important if you practice family law. And then also protections like DACA that offer sort of temporary protections from deportation and work permits for certain people brought to the United States as young people and meet other qualifications. Now, as I mentioned before, one huge limitation to a lot of these remedies and protections is if a person is undocumented. So that's a large population in Arkansas. So according to the American Immigration Council, approximately 55,000 non-citizens in Arkansas are undocumented. That's 2% of the state's population. And about 1 in 20 children in Arkansas, according to those same statistics, are a U.S. citizen living with at least one undocumented family member. So there are many Arkansans, who are undocumented, and even more who are living with relatives who are. It's important to mention here that while there are often very limited immigration remedies for people who are undocumented, it doesn't mean that they have no roots. So many people who are undocumented have lived in the United States for a very long time. In the Mississippi example, we saw people who had lived in Mississippi for 10, 20 years. As I mentioned before, they can often have U.S. citizen kids and other relatives, often have very tight, connections with their communities in the U.S., but can often offer, have very limited options, but I'll talk about some of those. So now that we kind of have a brief overview, I want to talk about some common immigration issues. Not only immigration itself, but how immigration might impact your practice areas. So if you practice family law, for example, as I mentioned before, there are special protections, immigration protections for children, non-citizen children who have suffered abuse, neglect, and or abandonment by one or both parents. And this actually requires some action in state court to get a state court judge to make that finding, if that is the case. And that protection is called special immigrant juvenile status. So if you work with abused, neglected, or abandoned children, this is something to keep in the back of your mind. If you do have a client who is a non-citizen, this might be an option for them. Family law proceedings can also impact certain family-based statuses. So as I mentioned, in immigrant visas, a large number of them are spouses coming to be reunited with U.S. citizen spouses. And those relationships, those legal relationships, if they're broken by divorce, then that can impact the beneficiary's immigration status. Also, things like student visas, all these non-immigrant visas that I talked about, asylum proceedings, people can be beneficiaries on an application or a visa. So if a person is a beneficiary and that relationship is broken, then that can impact the other person. So it's just something to think about. Also, there's a huge intersection between immigration law and criminal law. So as I mentioned before, if a person commits a criminal act or has a criminal charge or has a conviction, these in different ways can impact a person's immigration case and immigration prospects, if they have a pending immigration case or prospects in the future. Also, apart from sort of the overlap with other areas of law within immigration itself, you often see issues when people are trying to change statuses within one non-immigrant visa to another, or just statuses going from a non-immigrant visa or no status to a green card. Being undocumented can raise a lot of immigration issues that I talked about. You've got issues, a person might come to your office and say, I'm in immigration proceedings, I'm in immigration court, or I've been arrested by immigration and they've released me on a bond, what do I do? So that would be enforcement and removal proceedings. Or you might have somebody, we used to get a lot of calls, especially when I was at Catholic Charities in Mississippi, where an employer might call us and they'd say, I've got this employee I've worked with for a really long time. He doesn't have immigration status. What can I do to help him? Can I petition for him? Or you might have friends or relatives call asking for assistance for a loved one. So just to dive in a little more deeply, if any of y'all practice in these areas, family law or criminal law, now there are other, obviously, impacts with other areas of law, but these are the two most common in my experience. As I mentioned before, in family law, divorce can have an impact on somebody's immigration status. I mentioned also abuse, neglect, or abandonment of a child by one or both parents. Domestic violence also. So if you work and you represent survivors of domestic violence, if a client is a non-citizen, there may be special protections for that client, including U visa, or if the person was married to or is married to a U.S. citizen or permanent resident, there's a protection called VAWA, the Violence Against Women's Act protection. In criminal law, if you practice criminal defense, you know about Padilla versus Kentucky. That's the U.S. Supreme Court case that said that criminal defense counsel have a duty to counsel their clients, non-citizen clients, on the potential removal consequences of a guilty plea. The INA that I mentioned before has a whole host of grounds of inadmissibility or deportability, and those apply kind of depending on your exact situation. But many of them are based in criminal law. So if you can commit what's called a crime involving moral turpitude or an aggravated felony, those can have very serious impacts on your immigration case or prospects if you don't have an immigration case yet, and could result in the government trying to remove you, and even if you have a green card, trying to revoke your green card. Still, other immigration benefits have what's called good moral character requirements, such as a benefit called cancellation of removal or naturalization. If a person's trying to apply to become a U.S. citizen, there are good moral character requirements the government will look at, and that includes criminal convictions. For many of these, sometimes a conviction is not necessary. So sometimes just committing the act. For immigration bonds, it could be just having a pending charge that could get you a denied bond or a much higher bond. So even a charge can have an impact on things like bond. And for some of these, having admitted to committing the essential elements of a crime is sufficient, even if you're not convicted. On the flip side of criminal law, as I mentioned before, there are important protections for certain crime victims. So if you worked with victims of crime, this is something to look out for. Now, just to talk about what immigration options people might have. Again, this is not so, if you don't practice immigration, it's not so you have to, be aware of all the details, but just be aware of kind of the universe, so that if a client raises some, flags on some of these issues, you'll know kind of where to refer them out. There are two types of immigration protections, as I mentioned before. Affirmative, so for people who are not in removal proceedings or are seeking some kind of benefit outside of removal proceedings, even if they're in them, and then defensive, and these are all in removal proceedings. As I talked about before, generally for affirmative protections, you have to meet statutory eligibility and must not be inadmissible, and that's where a lot of people fail. Or they have to get a waiver if one is available. But for many of these, there are not broad waivers available, except for the humanitarian categories. So general categories are family. So if you have a spouse, for example, who's a U.S. citizen or permanent resident, if you have a U.S. citizen sibling, if you have a child who's over 21, who's a U.S. citizen, or if you're a U.S. citizen, you want to petition for a parent, these are relationships of people who can sometimes benefit from an immigration petition, a family petition. There are also employment and study options for people. And then talking about the humanitarian options again, there are many of these that are available affirmatively if people are not in removal proceedings. So that includes VAWA. VAWA is an important protection for people who are non-citizens but married to U.S. citizen, or divorced U.S. citizen within the past. You have a 2-year deadline after the divorce to apply for this protection. You could also be a parent of a U.S. citizen or permanent resident or child. And then you have to demonstrate that you have suffered battery or extreme cruelty by that qualifying relative, that qualifying U.S. citizen or permanent resident relative during that relationship. You also have to show that you have resided with your abusive U.S. citizen or lawful permanent resident relative, and you're a person of good moral character. So that's where this good moral character component also comes in. So for VAWA, there's a form that you fill out, and potentially at the same time, you could file for a green card for certain relationships. But that's a really powerful protection for victims of domestic violence who have suffered at the hands of a U.S. citizen or permanent relative, resident qualifying relative. A related protection that I talked about is the U visa, which is a non-immigrant visa. And this also protects victims of domestic violence. So in order to get a U visa, you have to be the victim of a qualifying criminal activity. And there's a whole list on the SIJS website and in the regulations. So most crimes of violence, including domestic violence, it also includes things like stalking, attempted crimes. So it's important to take a look at that list if you have a client who has suffered a crime in the United States. Also have to prove that you've suffered substantial physical or mental abuse as a result of that crime, and that you have information about that criminal activity, and that you were helpful, are helpful, or likely to be helpful to law enforcement in the U.S. in the investigation or prosecution of the crime, and the crime had to have occurred in the U.S., and there are very generous waivers available. So if your client has an inadmissibility, the U visa is one of the visas where there are really generous waivers. So this is something to think about if you have a client who suffered a crime. Just take a look at the list, see if it qualifies. The difference between you and VAWA is that you can be a domestic violence survivor and apply for a U visa. That's what you would go for if you did not have a marriage to a U.S. citizen or qualifying relationship to a U.S. citizen or permanent resident. So oftentimes you'll see this in cases of domestic violence where the person is not married to the abuser, or they're married and the abuser is not a U.S. citizen or a permanent resident. So U visas are really important. A couple of considerations about U visas though. You have to get a certification signed by either the law enforcement agency that investigated. You can also get it from the prosecutor's office if they are willing to support. So it takes a little extra work to reach out to those law enforcement agencies, but I've found that in most cases they're extremely supportive. If the person has been open and forthcoming about what they've suffered, if they've really helped in the investigation. Importantly, the government does not require that the investigation have led to an arrest or anything like that. Just the law enforcement agency has to certify that the person was helpful. And then we also have some other protections that are affirmative. So if you're not in removal proceedings, or if you're a child who is in removal proceedings, if you fear persecution, in some cases you can apply for asylum. There are some deadlines and things like that that are important, but that's just important to know. If the person, for example, is a recent entrant, you can apply for affirmative asylum. SIJS, if you practice in family law, is a really important remedy to know about. That's what I mentioned before, that involves children who have been abused, neglected, or abandoned by one or both parents. Also have to show that the child cannot be reunified with one or both parents because of that abuse, neglect, or abandonment. The child has to be declared dependent on the court or be placed in the custody of the state or someone else. And then finally, you have to show that it would not be in the best interest of the child to return to their home country. This is a really interesting remedy because it involves a state court prong. So the state court has to get involved, and a state court judge has to issue an order making these findings. This will often come up in abuse, neglect, or abandonment proceedings. So the judge will just add this language if the judge is convinced that these things are true, or can also come up in guardianship proceedings. So again, if you represent children or families who are pursuing guardianships, this is an important remedy to know about. Now, DACA, Deferred Action for Childhood Arrivals, is another protection, although it's put on hold for new applicants. So I won't go into a lot of detail about DACA since it's not open to new applicants. But if somebody comes to your office and has DACA, the government is still accepting DACA renewal applications. So that's important to know about. And then, sorry about that. Then it's also, just to go back, this humanitarian category is generally the best category for undocumented people, as long as they qualify, of course, because it has the most generous waivers and exceptions. But still remember here that many people still will not have an option because they might not have suffered a violent crime. They might not have suffered, they might not fear persecution in their home country. There might not be a child to qualify for SIJS who suffered abuse, neglect, or abandonment. So many people will not fit within these narrow categories and they just won't have an option. Oh, I forgot to mention T visas here. T visas are for people who have suffered severe forms of human trafficking. So those are really important to remember also if you have any clients who have suffered trafficking. Now, those are all affirmative. If somebody approaches you and they're in immigration court, if they're in removal proceedings, these are defensive options that are available in these proceedings if the person qualifies. So just to give you kind of an overview of removal proceedings. So as I mentioned, we have these immigration courts that hear removal proceedings all over the country. They're in many states, but Arkansas does not have one. So if you live in Arkansas and you're facing removal, you'll go to court either in Kansas City or Memphis usually. Mississippi was the same way. Our clients would go to Memphis or New Orleans. So these are administrative law courts, administrative law judges. And as I said, they're adversarial proceedings. In terms of access to justice, these cases are really critical because people are facing removal, which means, permanent separation potentially from the US, from their communities, from their families, from their loved ones. And those have serious consequences on their ability to come to the United States again. So removal proceedings are really severe, but unlike criminal proceedings, the government does not provide you counsel in these proceedings. There's a very small group of people. If the judge declares that you're not competent, they will appoint you counsel. But outside of that, the US government, in most cases, does not provide counsel for people facing removal. So this is an area where there is a huge need for people to become involved in taking pro bono cases. So, these cases are adversarial. You're facing an ICE prosecutor. If you're doing it alone, you're having to fill out all the forms alone. You're having to translate all your documents alone. All your forms have to be filled in on English. So for people who aren't familiar with English, aren't familiar with the US legal system, navigating complicated things like asylum is something that, they haven't had exposure to. So it's a totally different law, it's a totally different country's law. So this is an area where there's a huge need for immigration representation, for pro bono representation. Now, some common options in immigration court that result in immigration protections, and those include the authorization to live and work in the US. Those are things like asylum, so for people who fear persecution based on a protected characteristic, withholding of removal, which is related, and protection under the Convention Against Torture for people who fear torture. And then there's another protection called cancellation of removal that you might hear about. This is where having long ties and family members in the US can make a difference. So there's two kinds, one for people who are green card holders and facing removal, and one for people who have never had status or lost their status. So the green card one is rare, so I'm going to talk about what's called non-LPR cancellation. So for that, you have to prove you've been in the United States for 10 years continuously. You have to prove that you've had good moral character for 10 years. So remember when I talked about that important component, that good moral character is critical. You have to prove that you have not been, you have to demonstrate you've not been convicted of certain offenses that are listed in the Immigration and Nationality Act. And you have to show that deportation or removal would cause exceptional and extremely unusual hardship to a US citizen or permanent resident spouse, child, or parent. So that's where those relationships the court will take into consideration for a benefit. So this is something that's beyond the harm that people had suffered by being separated from a loved one. It's something exceptional and extremely unusual. It's a very high bar. Usually it's something like the U.S. citizen spouse or permanent resident spouse or child has a severe illness. So it can be one thing that's really extreme, or it can be multiple things that when taken together are seen as exceptional, extremely unusual. So it can be, for example, that a child has a minor chronic illness, another child might be receiving special services in school and would not have those options outside the country. And it may be that the spouse, for example, is unable to work and relies on the spouse facing removal for their income to support the family. So it can be multiple things when taken together, the court would see as exceptional, extremely unusual. There are other options in removal that don't result in a status, but might allow a person to remain in the United States, at least temporarily. That can be things like prosecutorial discretion. It's ICE agreeing basically to drop the case against the person. Could be administrative closure. So that's taking the case off the calendar, but it remains on the docket. But it's just closed. It can be reopened at any time. And then termination, so totally removing the case from the docket. And then another option, if the person wants to leave or may not have another option, they can take voluntary departure in some cases, and it means they can leave without a removal order. There can still be other immigration problems that are triggered by that, but in some cases, the consequences are not severe. And then for somebody facing removal in immigration court, sometimes affirmative options that I talked about in the last slide are also available, like family petitions, like VAWA. So they can apply for those simultaneously and basically notify the court that it's happening, keep the court updated. Now, finally, I want to go over some screening questions and red flags. So depending on the area of law that you practice, and depending on kind of the types of clients that you see, if you normally see non-citizen clients, these are some things that you might want to consider, you might want to ask people about, you might want to refer out if it involves an immigration issue. So if you handle criminal defense for non-citizen clients, of course, be familiar with Padilla versus Kentucky, as I'm sure you all are. The details on current criminal charges and details on any criminal history. So obviously for the for their criminal case, but those can have a huge impact on their immigration case. Simultaneously, you may have an immigration attorney reach out to you. So I've had people facing criminal proceedings before who are working with criminal defense counsel who then reach out to me for immigration assistance because ICE might have then, moved them to removal proceedings. So they might now be facing removal. So immigration attorneys might reach out to you for this information. Often immigration attorneys will need certified copies of all the criminal conviction records and court records. So just know that they might be reaching out to you, and know that if your client is facing these charges, there might be simultaneous immigration proceedings happening too. If you have family law cases for non-citizen clients, if your client is in a divorce case, divorce proceedings, you might want to ask whether their spouse, whether they have an immigration benefit that's dependent on their spouse. And then sometimes, of course, unfortunately, domestic violence will come up in these intakes and discussions. So if your client is not a U.S. citizen and they raise domestic violence, or if you have a indication of it, then that could be something to ask about, because that might be a ground for some protections that I mentioned before. If you handle child custody or guardianships, you might, for non-citizen clients, you might want to ask if the child has been, or be aware of whether the child has been abused, neglected, or abandoned by one or both parents. It's important that it does not have to be both parents. For SIJS purposes, one parent is sufficient for this protection. So kind of be aware of that if you work with non-citizen clients. And then generally, just things to think about, regardless of your area of law. If a person is, tells you that they're not a US citizen, you might want to be aware of their immigration history, their current immigration status, country citizenship, whether they've been in removal proceedings before, or whether they are in removal proceedings before. Because if they are in removal proceedings, that can have an impact on kind of their future here in the United States. If they're ordered removed, for example, they might have to leave the United States. It's just important to keep that in mind. Might want to ask about family in the US and their immigration statuses. If they have somebody close, like a parent, a child, or a spouse, for example, who's a US citizen, that could be a potential immigration option for them. Obviously, criminal history or history of domestic violence, or suffering any other crime in the US. And then, are they scared to return to their home country? They might just express that anyway. And then also, what are their immigration goals? So if you have any of these issues that pop up, these are sort of red flags for referral to immigration counsel if you yourself don't practice immigration. And again, these are the questions and things to think about, if you have a client in one of these other areas of law. I want to mention also some referral and pro bono opportunities. So we of course at the Immigration Clinic at the University of Arkansas have some pro bono opportunities for people who are interested. If you have a potential immigration case and you don't practice immigration, you're not familiar with immigration, and you want to refer them out, the Immigration Advocates Network has an Arkansas Immigration Legal Services Directory. So these are nonprofits in Arkansas that handle immigration cases. Now, this is not an exhaustive list, but this is a good place to start. For private attorneys, you can also consult the International Law and Immigration section of the Arkansas Bar, or AILA.org. So that's the American Immigration Lawyers Association. They have a directory of attorneys also who work in immigration. So these are all things to think about and look at. So now I'd like to open it up for discussion. I'm wondering if anybody has any questions. It looks like, okay, I'm gonna actually look at the Q&A box. Looks like we have a couple. So somebody said, can you give a common example of non-immigrant versus immigrant? So that's a fantastic question. A non-immigrant example would generally be somebody who is here on a temporary visa for a temporary amount of time. So that would be, for example, students. They're on F visas or J visas. They're allowed to be in the United States for the duration of their studies, and then with some optional practical training time, and then their visa is expired unless they extend it or somehow change to another status or adjust their status. Other examples can be U visa holders. So like I said, the humanitarian types of non-immigrants. H-1Bs are pretty common, and like H-2As, for example, like certain types of agricultural workers, H-2Bs and H-2As, certain types of agricultural workers. H-1Bs who are in specialty occupations, so they are often working as, say, accountants, working in technology. And then you've got, for example, certain types of temporary visas for like artists, but they're here for a temporary duration. The immigrant would be, say, somebody who's coming on a green card because their family member petitioned for them and they're eligible for a green card. So they come on an immigrant visa, meaning that their intent is to stay and permanently, and then they are given a green card once they come to the United States. And then another example of immigrant is somebody who an employer has petitioned for them, not for this temporary non-immigrant visa, but for a long-term permanent green card. And that process is a lot more arduous, as you might imagine. So that's a good question. And then Jacqueline asked if there will be handouts that we can print. So Abby, I'm understanding you'll send out the presentation itself. If anybody has any questions about particular issues, and you would like more information on a particular issue like SIJS, like U visas or VAWA, please feel free to email me. My email is on the previous slide, and I would be happy to talk to you more in detail about any of these resources or send you any handouts on particular forms of relief that you might be interested in. So Lisa asks, so the child in an abuse or neglect case would not have the protections of SIJS until the judge makes a finding that they can't be reunified. Sometimes that finding does not come until the end of the case, so no protection until that time. That is a great question. I'm glad you raised this question because the timing of SIJS is actually really complicated. Once they have that finding by the judge, the state court judge, that actually does not provide them with immigration protection. The child then has to take that form, the order by the judge, and submit it to USCIS that I mentioned before, and they have to adjudicate what's called a special immigrant juvenile petition. That petition in itself, even when that's approved, and that can take like a year, it's supposed to be quicker than that, but it can take like a year. Once that petition is approved, that only puts the child in line for a green card. And there are quotas. I'm glad you mentioned this for a couple of reasons. First, for SIJS, and second, about quotas. For many types of both immigrant and non-immigrant visas, there are quotas on how many visas the US government can give out per year. SIJS is one where there are really heavy quotas, really kind of strict quotas, and much more demand than visas available. So sometimes children have to wait several years before they can get their green card. And that's when they're actually protected in immigration law. So the protection can come usually after several years. Now, that being said, if a child has this order by a state court judge, normally what would happen in many cases, not always, but ICE has the discretion not to remove a child if they have this order. So in my experience, not every officer is the same, but in my experience, I've had some child clients who've gotten this order, they're in line for a green card, they don't have it yet. And you can, in some cases, show this order to the ICE officer and show that they have, this petition in progress, and they will use their discretion and not, work to remove a child from the country. So that's something to think about, but it's not a perfect protection, unfortunately. Very, very good question. Susan asked, what are some of the most common or frequently litigated immigration issues in Arkansas? So that's a really, really good question as well. A number of issues around Arkansas are, we've already, at the clinic, we've been contacted by, some employers who are seeking to sponsor workers. So especially like workers in the poultry industry or meatpacking industry, asking how they can help their employees get some kind of immigration status. That's a pretty common issue that I've even experienced in my short time here, people trying to find protections for workers. Another pretty common issue, so, what we focus on is we focus on people who are facing removal generally. So that's a fairly common issue, even though there's not an immigration court here, since there are, 55,000 at least undocumented people in Arkansas. That's a pretty common issue, people facing removal. Other issues, we see a number of domestic violence type cases. So these are all affirmative proceedings, though. Like most of the VAWA cases, for example, are domestic violence, or are affirmative proceedings. So they're not like an adversarial proceedings or anything like that. But that, unfortunately, is pretty common. Something that we see a lot. And also people who are victims of crimes. We get a lot of calls about that, people who are targeted. What we see, and what I saw in Mississippi too, are, in areas where there might be a high immigrant population and a high population that people perceive to be undocumented, people who are, committing violent acts might think that, oh, they're undocumented, they might not go to the police, they might be scared to go to the police, you might be holding a lot of cash. So in Mississippi, they were often frequent targets of violent crime. And we've seen kind of the same trends here with some of the clients we have pending for the immigration clinic. So that's another good question. And then Gina asked, yeah, what if a U.S. citizen spouse dies? Can a green card be revoked on that basis? So there are very particular provisions on what happens if a spouse dies. In some cases, it's possible to still pursue your petition because of death. But it's a very particular, and I can send you if you're interested in that very particular sort of question, I can send you more information on that. But there is a provision for that that does allow for the continued, processing of that petition, even if the spouse has died. So unlike divorce, it's treated a little differently in most cases. Abby, are there any particular things that you're thinking about or any other questions that people are having? I know we have some more time.
Sure. And also I put this in the chat, but for those of you who haven't had a chance to read it yet, if you do have a question and you'd rather just vocalize it rather than type it in, that's totally fine. There's a button at the bottom or somewhere on your screen that says raise hand. If you click on that, I'll be able to see, and then I can unmute you and you can give us your question there. In the meantime, I do have some questions. So there's a little bit of an ethical dilemma here when you're doing immigration cases, right? Because, and it's kind of similar to a law firm that represents an insured and the insurance agency. So you've got in a lot of these cases with petitions, you've got a petitioner and then a beneficiary. So who is your client? Who are you representing?
Yeah, that's a really good question. And thankfully, I don't do family petitions really. So that's something that you don't face in asylum because you're, just representing a person who's facing removal or, on their asylum application. But other attorneys who do handle these types of cases, I understand. So you've got it both in the family context and you've got it both also in the employer-employee context, because you also have types of petitions where you've got an employer who's petitioning for somebody to come work for them. That person might be here in the United States, and there might be a difference of opinion, right? So there might be a person, the beneficiary or proposed beneficiary changes their mind, doesn't want to work for this person anymore. So what I understand a lot of attorneys do for these types of cases is they have an agreement. Let's say, use a family example. You have both spouses, for example, and there's something in the agreement that says if, at any point one client's interests, diverge from the others, there's a difference in opinion on how to proceed, then, this agreement is terminated, basically. So some kind of provision like that. Often, I think when people are representing spouses, they're representing both parties, but that can fall apart, as you might imagine. I think that's why they include that provision, and then they will not represent either one. I think is how they handle that. That happens, and just refer them out.
Y'all keep those questions coming if you have them. So here's another question I have for you. Are there any paths to citizenship or some type of status or protection for families of U.S. military personnel?
Yeah, so there is a really important protection for families of U.S. military personnel that's called parole in place. And this is kind of dig into the weeds a little bit, but it's a really, really important point. So remember when I talked about to get a green card through family or through work, one of the requirements for a green card is that you had to have entered with inspection or parole. So if you've entered without inspection, then you can't meet that requirement. So it's a lot more complicated process. It means that your family member files a petition for you. You wait for a visa to become available because sometimes there are quotas depending on your category. And then once there's a visa available for you, you have to, or actually before that, you have to apply for a waiver in some cases, and then you have to leave the country for an interview and then come back after your interview. And If the waiver that you can apply for from the United States doesn't cover every ground of inadmissibility, you have to wait longer outside the United States. It's really complicated and difficult. There's an exception though, if you have a immediate family member who is in the U.S. military, who is active duty, who would suffer hardship if you had to leave the United States, basically. So basically what the U.S. service member needs to do is write a letter explaining how this person's departure from this relative's departure from the U.S. would hurt them. And they can be granted what's called parole in place. So basically it's the U.S. government saying you haven't physically left the United States and re-entered, but legally you're doing it. So we're granting you this parole, which is kind of like a new entry. So it means they don't have to leave and come back. So this is called military parole in place. And I've done a few of those cases, and it's a game changer because it means that the relative doesn't have to leave to go for their visa interview outside. They can stay here with their family and support their family member. So it's a really powerful protection. So that program has been sort of it's wavered over the past years. So in some years, USCIS has kind of adjudicated those cases in full force. Other years, those military parole in place cases have just kind of disappeared into the ether. Like they've not really made it a priority, but thankfully I've seen, in the past several years, the cases have been granted. So that's a really important protection. And that's kind of a broader point, just when we're talking about people who are undocumented, that's an additional barrier, right? Is not having that lawful entry. And so for things like adjustment, even when they have a U.S. citizen relative who can file that petition for them, they're stuck and they have to go through this sort of roundabout process. But that's a really important exception, is the military parole in place.
That's a good point there. And we do have a question from Susan. I don't know if you want to read it. If you can.
Yes. Let's see. Okay. So Susan asks, scenario: an individual came to the U.S. on a non-immigrant visa and overstayed, then married a U.S. citizen, wants a green card and then citizenship. What's the path and how long does it take? What's the average length of time to get to citizenship generally, and is it significantly longer for certain types? Now, this is a great scenario because, as I mentioned before, you've got all the problems that the person went entered without status, but this person came as a non-immigrant. So they entered with inspection. They would have talked to an officer. They would have been given authorization to enter with their non-immigrant visa. The fact that you overstayed if you married a U.S. citizen, there is a waiver for marrying a U.S. citizen after you've overstayed. So they can do everything within the United States. So that's a huge benefit. Another benefit is if you marry a U.S. citizen versus a permanent resident, there are quotas on marriages or green cards through marriage to a permanent resident, but not U.S. citizens. So visas are always available. So it means that basically the only wait time you have is the processing time for the case. So you could actually file the petition and the green card application all together, and that's called adjustment of status. Generally, like I said, I don't do those cases. I don't work on those cases, but from my understanding is that those cases are taking, the green cards I know they're really far behind on. So it might take about a year, it might take longer. But one thing that's beneficial if you are eligible for a green card, like this person would be, unless there was some other red flag in their history, is when you have this application pending, this green card application pending, if you're eligible for the green card, while you're waiting, you can also file an application for a work permit. And that means that if it's approved, the person can get the work permit while their case is pending. Even if the case takes 2 or 3 years to adjudicate, that person can be working. They can get a social security number if they didn't get one before. So that can be something that's really powerful for people. Because the way a lot of these cases come up is somebody will actually, we get a lot of cases where somebody comes in, they just say, I want a work permit. And so then you have to kind of work backwards, find out how they got here, what their situation is. But that work permit is critical. Not only is it just authorization to work, but it's, it means they get a social security number. It means that they have a lot more sort of broad array of employment options available to them. It does say on their card that it says not valid, the social security number, it says it's not valid without authorization, but as long as they have a work permit that's valid, they can work. So that's a really powerful thing to have. For a lot of these cases, like asylum, if you have a pending asylum application, you can also get a work permit once it's been pending for 180 days. So a lot of these things can get people work permits while they're waiting. So that's really important to remember, because a lot of people understandably will be antsy about that and want to know how they can get that. Abby, if it's okay too, I just want to talk, oh, thanks, Susan. I want to talk a little bit about, like, if somebody's interested in taking a pro bono case, kind of what that looks like. Would that be all right to talk about? So a lot of people, we get a lot of calls. Well, I'm new here, so we've not gotten a lot here yet, but back in Mississippi, get some calls from people, attorneys who work in other areas, who are interested in taking on a pro bono immigration case, but don't really know what that looks like. So if you're thinking about it, I can just sort of briefly talk about that. One option is to take a case that sort of overlaps with the area where you practice. So we had some attorneys in Mississippi who were family law attorneys who, I used to do some SIJS cases. They would go to state court and help with the required order. Once we were able to get that order, then we would work on the, petition with SIJS and later the green card application. Or sometimes, we would assist that attorney in filling out those forms themselves if they wanted to kind of see what that immigration process would look like. Other types of options, we have some attorneys who had gotten involved in affirmative asylum cases, and then some people who wanted to take on a removal case. And those can be a little more daunting because, it is an adversarial proceeding. It is a bizarre situation because sometimes around here your judge will be with you, but sometimes if you do a detained case, your judge is appearing like on Skype. It's really, really strange. But those can be a little more daunting. So some people want to start off and work on, say, an affirmative asylum case. Those are handled at asylum offices, so they are not adversarial. The nearest office, unfortunately, is in New Orleans, so it's really far away, but the officers will often circuit ride up here. So they'll come to, say, Memphis or Fort Smith even to hear cases for people who live up here. Because transportation, of course, is often an issue for clients. So that's really helpful. Those cases can often take 2-3 year. I mean, that's both a benefit and a downside, right? Because it's a lot of time to prepare, to kind of learn about this area of law, to get the support. So, we would provide the mentoring support, but at the same time, it's a very lengthy case. You can prepare everything, have it filed, and you're just basically waiting for an interview. And many of these offices are so backlogged. The asylum offices are taking about 2 or 3 years. Immigration courts, you'll often have a case started and you might not have a final hearing until 4 or 5 years later. So they're very lengthy cases. So what we've had attorneys do in the past is work on a part of a case. So help do, one thing that's really important in asylum is demonstrating country conditions. Working on a case now for a client from Honduras and who fled domestic violence. So it's getting country reports together, explaining domestic violence protections in Honduras, talking about the dangers of going to the police in some cases, getting together expert declarations. So sometimes it can be a component of a case if you're interested, but you don't want to take kind of a full removal case. But you'd like to get kind of that experience and also help out a client. So those are kind of just some options if people are interested. But please feel free to reach out. I'm happy to talk about kind of where you can get plugged in. We also do, I'm also working with the Springdale Public Library to do some legal clinics. So, I'm just going to talk about immigration issues, but if you wanted to do like just an overview of family law, and we could have an interpreter there. We're trying to get people, access to these issues in other languages. So, we'll have interpreters there. But if you want to talk about a particular area of law, give an overview. I think that those types of things would be really helpful too. And that's not, as much of a commitment as like a 4-year long case. So, please reach out if there's anything you'd like to do to get involved. We'd very much appreciate it.
Excellent. Well, thank you so much, Amelia.
Absolutely.
Coming in to do this presentation for us.
Thank you.
I've been thinking about this topic for a while and hoping that we would eventually find some way to work it in, because I think it's really important, and it's kind of an overlooked area, especially talking about those intersections between family law and criminal law. Thank you so much.
Absolutely. And to be a state where immigration is growing so much, I think maybe areas and places, where that had not previously thought about immigration, now it's becoming a really important issue.
Yes. I was just in a meeting with a group from SIJS, United States Immigration and Citizen Services, something like that. And they were talking about this new commission or what would you call it? Some type of initiative.
I was in that call too. Yes.
That we had talked about before. And it's just